This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we explain why in California now, insureds have been made more equal than their insurers, and why the California Court of Appeal extended the meaning of a statute to make an insured more powerful than the insurers at an examination under oath. Because to protect the insureds, the court allowed the insured to harass the insurer and make a production out of an examination under oath. As George Orwell explained in his novel Animal Farm, we are all equal in the eyes of the law, but some are more equal than others. In Vladimir Myashyankin versus Nationwide Mutual Insurance Company, the California Court of Appeal on January 30, 2024, decided over the dissent of its presiding judge that the insured in a disputed claim where an examination under oath has been demanded is more equal than the insurer. Residential property insurance policies commonly require, as the standard fire policy, an insured to submit to an examination under oath, an EUO, if requested by the insurer in connection with the resolution of a claim. Insurance Code Section 2071.1, Subdivision A, Subdivision 4, provides that an insured subject to an examination under oath, quote, may record the examining proceedings in their entirety, close quote. In an issue of first impression, whether the statute also entitles an insured to make a video recording of the insurer's participants as well as the recording of the insured's testimony in an EUO. After considering the statute's plain language, statutory framework, and legislative history, a majority of the Court of Appeals concluded the provision does confer such a right. The case began because of a water damage to his home. Plaintiff filed a claim under his property insurance policy with Nationwide. Pursuant to the policy terms, Nationwide required the plaintiff to submit to an EUO, which was scheduled to be in person. Relying on Section 2071.1, Subdivision A4, the plaintiff sought to video record the entire proceeding, including Nationwide's attorneys and claims adjusters. Nationwide refused to proceed with the EUO, asserting Section 2071.1 only permitted plaintiff to video record himself. Further, Nationwide threatened to deny plaintiff's claim unless an insured's compliance with a policy requirement to submit to an EUO is a prerequisite to the right to receive benefits under the policy. Examinations under oath are frequently conducted under circumstances where the loss is undocumented or suspect. The purpose of the examination under oath is to enable the insurer to obtain information necessary to process the claim. The examination is normally conducted orally before a court reporter who administers the oath and transcribes the proceeding. The plain language of the statute provides an insured may record every element and part of the examining proceeding, just as an insurer may by the means of a certified court reporter or a video. Like a videotape deposition, only the face and statements of the witness are viewed, while questions and answers are recorded. The Court of Appeals noted that the legislative history of the statute did not explicitly address whether Section 2071.1 encompasses the right to video record the insurer's representatives. However, it demonstrates an express and unequivocal intent to protect insureds from harassment in EUO proceedings. Significantly, video records nonverbal conduct such as eye rolls or glares, which would not be captured by audio recordings or reported transcripts. In addition, the knowledge that a person is being video recorded may prompt the person to modify their behavior in a positive manner, and that, in fact, is the reason why the plaintiff wanted to record the others, especially the insurance adjusters who are not professional lawyers. The Court of Appeals concluded that the plain language statutory framework and legislative history all support a construction of Section 2071.1 granting insureds the right to record the proceedings, including more than one video recorder, since one would point at the witness and the others would point at everybody else in the room, which could require a complete production studio as if they were filming a motion picture. Presiding Justice Terry L. Jackson dissented because she disagreed with the majority's interpretation of Section 2071.1. Justice Jackson noted that had the legislature wanted to confer specific recording rights, it could have done so, as it is done in a variety of other contexts. For example, persons attending various public meetings shall have the right to record the proceedings with an audio or video recorder, as stated in Government Code Sections 11124.1. Justice Jackson also noted that there is little, if any, discussion in the legislative history about 2071.1 recording methods, and what minimal references they are not mention an insured's right to video record an insurer's participants. Case law has long confirmed an insurer may contractually require as a condition of coverage that an insured submit to an EUO. She concluded that, quote, from review of the plain language of Section 207.1 and its legislative history, together with the applicable case law and statutory scheme, the conclusion is that 207.1 does not give an insured an unqualified right to video record an insurance company's participants in every instant, and or a concomitant right to refuse to participate in an EUO unless the specific method of recording is permitted. In my opinion, the only purpose of recording the facial expressions and appearances of lawyers representing the insurer or of insurance claims people in an EUO and any representative of the insurer is to harass, intimidate, or make the process of the EUO too expensive. The statute requires the insurer provide the insured without cost with a copy of the transcript of the proceedings, and if recorded by oral or video recording. Adding a second or third video record is only there to intimidate or lessen the inquiries of the insurer faced with a potentially fraudulent claim. Hopefully, the case will be taken up to the California Supreme Court to consider the well-reasoned dissent of Justice Jackson. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You'll receive notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,800 blog postings. You can also subscribe to these videos on rumble.com or on youtube.com, and if you do, I'd appreciate it if you click on a thumbs up button for rumble.com or a like button on YouTube. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.